Good afternoon, everyone. It is Tuesday, January 25th, and welcome to our land use meeting and public hearing. If you'll all rise and join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. Mr. Ingalls, do we have certification of the agenda today?
Mr. Chair, that is something we're going to have to talk about. Normally, I would cover the forms of notice and tell you you have jurisdiction to proceed, but there's a question of substantial compliance that we'll have to have that discussion.
Thank you, Mr. Ingalls. Would you like to walk through those issues now, or would you like to wait until that comes up in our...
Mr. Chair, apologies if I may interrupt. It was brought to my attention based on something that has been communicated to me by the applicant, and under advice from counsel, I will be recusing myself from this matter.
Thank you, Commissioner Teal. And we will get to Commissioner disclosures on item 1C. Thank you for sharing that with us and appreciate your recusal. Going back to item 1B in terms of certification of the agenda, Mr. Ingalls, would you walk us through any additional issues that we need to be aware of on that?
Yes, sir.
Thank you, Commissioner Teal.
So for this item, there was 3 forms of notice required. It was posted notice on the property, mailed notice to abutting landowners, and published notice. Those are all forms that are required by Section 15 of the zoning resolution. This is a PD rezoning issue. And in those notices, all 3 of the forms did not have the time of the hearing. So normally when I would cover notices with you, me and my staff will have confirmed that all of the elements of notice were present, and we simply won't have a discussion. I will tell you, you have notice and you have jurisdiction to proceed. But because there's an element of the notice that was not present, there becomes a question of whether there is substantial compliance. And that is a board decision. It's not something I can summarize for you. It's a discussion that the 2 of you will have to have and decide. Do you want me to walk you through why that may or may not be a concern?
Yes.
Okay. I'm scrolling to that now, but this application is under Section 15 of the zoning resolution. And in all of our zoning sections, as well as our subdivision, we have a required and prescribed form of notice. If I recall correctly from looking this up just a little while ago, yeah, it's Section 1511 is the notice that's required for a rezoning PD. And it covers the time frames within 15 days prior to the Planning Commission, et cetera, et cetera. But when you go down to the actual form of notice that's required, I will just pick one of them and then read it for you. So here's one. Notice of a public hearing before the either Planning Commission or Board of County Commissioners. This land shall be considered for a change in zoning from, you identify the zone district that it is currently in, to PD, plan development. This public hearing is, parentheses for filling in the date, in the Commissioner's hearing room with the address at, parentheses, time, you fill in the time. For more information, call Douglas County Planning at, and there's a phone number for our planning department. And then it has the file number. So that is an example, but for all 3 forms of notice, there are those same blanks. There's a blank for the date, there's a blank for the time, and there's a blank for the file number. None of the 3 forms of application on this particular item had the time, so 230 was not present. If there is substantial compliance of notice, that is a decision for the board, so I thought you might want to see a definition of substantial compliance. I just went to something fairly neutral, Black's Law Dictionary, but I'll read you the definition. Substantial compliance rule, compliance with the essential requirements, whether of a contract or of a statute. So the question then becomes, is the essential requirement of time an essential requirement? The Planning Commission determined that it did have substantial compliance. Essentially, as I understand it, they determined that because there was a phone number, because there was a date, because there was more information, people with reasonable inquiry could get all of the information they needed in order to be heard should they choose to show up and be present. And so they determined that with that additional consideration, that it was substantial compliance. So the question then becomes to you the same. Do you have substantial compliance with the notice? And if you do, you have jurisdiction and you can consider the request for continuance. If you don't believe you have substantial compliance, this item needs to be renoticed, and it would need to go back to the Planning Commission, then back to the board. I was asked before the hearing, and I believe planning could confirm this, that obviously if you grant the continuance to February 8th, this would be heard on February 8th. If this needed to be renoticed starting today, the item would not get back to the Board of County Commissioners until March 8th. So it would cost essentially 4 weeks of time.
Okay, thank you for that. Any questions for Lance about certification of the agenda?
I have none, thank you.
You know, I appreciate the definition from Black's Law around substantial compliance. Do you have information about any recommendations that the Planning Commission may have made with regard to this item?
I don't have additional information. I know that decision was made with the support of my office. I was not involved in the conversation at that time. And the discussion was really akin to a land use type. If you have inquiry notice, you have enough notice that you would be put on an obligation to inquire further, and therefore you have all the information you needed. That was the logic that was applied. I'm not sure that logic in a land use setting necessarily applies to a prescribed notice like we have here. But I do think you have the discretion to determine otherwise.
Well, thank you for that. And that is an important legal distinction between actual notice, inquiry notice, and constructive notice. Your indication to us, pursuant to Black's Law and other jurisprudence, would be that actual notice is required. Am I understanding that correctly?
Yes, substantial compliance with the actual notice requirements.
With the actual notice. So reasonableness aside, actual notice would compel us to provide notice that would include the date as well as the time of the hearing. And it sounds like, based on the record, there was not notice of the time.
There is a blank for the time in all of our forms of notice, and for whatever reason, that was not included in the notice provided on this application.
Okay. Well, as one commissioner, I certainly do have some concern about notice that does not provide the exact time. I recognize the Planning Commission's recommendations with the advice of counsel, but also recognize the more granular analysis provided by counsel today with regard to actual versus inquiry and constructive notice. In my view, actual notice was not provided nor substantially complied with. And in order to honor both the public and the applicant and avoid a 106 or other challenge on this particular item, should it come before us on the 8th, I'm inclined to accept council's recommendations on this item, deem this not certified for today's agenda, and direct staff to properly renotice this item for the public. Is there any further discussion?
I agree.
Can
Okay.
I ask staff before you vote on that or before you move on if I have misstated anything or missed anything? I'm seeing shaking heads, so.
So, Mr. Ingles, do you want a motion not to continue this, or what? How would you like how would you like me to word this motion?
Honestly, if you do not believe we have substantial compliance, you do not have jurisdiction on this item, you do not need a motion.
Okay.
We don't need a motion. Let me, since we have one commissioner that made disclosures indicating that he had to recuse himself from this item, let me ask if any other commissioners have disclosures for the item that is on this agenda today.
I have none.
Okay, and I have none either that I am aware of. With that, I guess we'll return to the issue of certification of the agenda. If you don't need a motion, it sounds as though we do have consensus that this agenda is not certified or appropriate for us to hear today. And does staff have enough direction to renotice at this point?
I see nodding heads.
Okay, thank you. With that, we will move on from that item to item number 3, public hearing agenda items. There are no items for today. And with that, we are adjourned. Thank you very much.